that the victim is dating. But there's no, what purpose is it involving John in any of the messages?
I think from Mr. Hamm's perspective, the purpose was that this is somebody that, you know, that he felt was likely to have some information about his daughter, and was hoping that he would learn something. And I understand, and I understand the Commonwealth's perspective is that those messages, those 8 or 9 text messages became increasingly aggressive. And I would argue that they perhaps were increasingly concerned. Here's a man who has no information about the well-being of his child, and who's trying to get information about how his daughter is doing. Yeah.
I'm sorry to interrupt. But you've made a challenge to the sufficiency of the evidence, and we must view the evidence in light most favorable to the Commonwealth, not to the defendant. So the fact that you could offer alternative inferences, or you can view the evidence differently than the Commonwealth does, we don't have that luxury. Yes,
I understand that, and so I'll go back then to the standard that I'm really trying to show here is, you know, the issue is whether those 8 words were incidental to allowable contact. You know, there's no question that all of the other sentences, all of the other statements in those texts were completely permissible under the terms of the order. And the question is, are these incidental to that permissible contact? And the Commonwealth needs to prove beyond a reasonable doubt that it was not incidental. And my argument is that they didn't do that. They didn't prove that there wasn't this statement was not from Mr. Hamm a good faith attempt to follow the rules, to a good faith attempt to contact his ex-wife about the care of his daughter. It was related to it because this was a person who presumably knew about how she was doing.
Rumeliotis?
Yeah, of course.
This is Judge Sachs. Couldn't the jury reasonably have concluded that if Mr. Hamm's purpose was to communicate that he was inquiring of John about his daughter, that he would have said in the text, I'm concerned because I haven't heard from you, so I've tried to get in touch with John to see what he knows about how Alice is doing. But instead, just a reference out of the blue to John will be getting a hold of me later couldn't the jury take that as sort of a shot across the bow, as I think the judge said below, that he's telling his estranged, now former wife, that he's aware that she's in a relationship, and that so she could be afraid that he is following her doings and in a sense even stalking her, not in a legal sense but in a practical sense.
Yes, I understand that, and I think that although perhaps the text could have been worded better, and perhaps a few more words could have made it its purpose a little clearer, I don't believe that the lack of those few words takes it out of the realm of being able to consider it as not being incidental to the legitimate contact. Would it have been? We wouldn't be here, I don't think, if those extra words were added. But I don't see how the lack of those extra words takes it out of being able to consider it as, you know, his good, reasonable attempt to learn about his daughter. And again, you know, unlike some case law that I referred to in my brief, where the language gets very threatening, very aggressive when the court says, you know, this crosses the line. You can't use this type of language when you otherwise are allowed to contact your, you know, ex-wife or whoever about your child. When the language becomes too aggressive, too hostile, that crosses the line. That didn't happen here. The language is very calm. It's very to the point. It's very brief, perhaps too brief. it does not feel like it rises to that standard. Excuse me.
Obviously, there are two different interpretations that one could put on this language. Isn't it up to the jury to decide which?
But it's up to the onus is on the Commonwealth to prove it beyond a reasonable doubt, and I don't see that was proven beyond a reasonable doubt here. It is possible to perhaps come up with many different interpretations as to what this particular language meant, but that's not the point. The point is for the Commonwealth to establish this beyond a reasonable doubt that this statement was not incidental. And obviously our argument is that did not happen here.
Did you want to say anything about your other issue?
And with respect to the other issue 2, I am happy to rest on the argument that is already in the brief on that.
Okay, thank you very much.
And thank you.
Mr. Townsend.
Thank you, Your Honor. Thomas Townsend for the Commonwealth. With respect to the issue that's argued here today, the required finding, the denial of the 2 required finding motions, I submitted it was a jury question. The defendant gave his take or his reasoning or his intent, and the Commonwealth is entitled to rely on inferences. And the judge instructed the jury that this was an issue for them. On page 135 of the transcript, he instructed, you should consider all the evidence in the case to decide whether any contact that was made in good faith for a legitimate reason, or whether that reason was merely a pretext or excuse for contacting the protected party. Now, the prior 9 text messages were all very brief, pretty much identical, asking, how is she doing? And there were no responses to those. And as mentioned before, there was a growing hostility to the text messages. And then for the 10th came the standard message, how is she doing? Followed by, John will be getting a hold of me later. Now, that is the most uncharacteristic text. It puzzled and frightened the victim because there was no John involved in her daughter's caretaking. No teachers, no neighbors, no babysitters, no doctors. And so she thought, who could this be? Well, she had begun dating a person named John over the past couple of months. And as the prosecutor argued to the jury, I think this is an entirely reasonable inference, it was a way of saying, I know you're in a relationship. I know who you're in a relationship with now. And so it's a smart alecky way of saying, I'm on to it. I know what's going on. And the judge had the similar interpretation at sentencing where, as mentioned before, he said, this was really a shot across the bow. So it was a reasonable inference. It's one the judge took at sentencing. It's one the prosecutor took. I think any reasonable juror would be entitled to take that interpretation. The defendant testified. He gave his reasoning, his explanation. The jury rejected it. And even it's very strict. The exception here should be strictly construed. It was a no contact order. It was modified to present one exception. And the word only is included in the exception. It says you may text each other only about the care and parenting time with their daughter. Now, I cite to the Stewart case, which I think is a good analogy. In that case, there was a 50-foot exclusion zone, but the defendant in that case was permitted to intrude on the exclusion zone, provided he remained in the car for drop-off and pickup purposes of their child, while the defendant walked the child to the door. And this court said, no, that is outside the lone specified exception. Here, it's just as clear. He could only text with respect to parenting, time, and care of his daughter. He learned through whatever means that the victim was dating a person named John, and he put that in with, he tried to mask it by asking about the daughter, but then asked about John. And she took it, the victim took it as a frightening text and a puzzling text, because how did he know about John? Because there's no indication that he would have known. And I think that he was trying to be cute about it, but he did violate the terms of the restraining order exception in that case. Unless there's further inquiry.
Is this a case implicating the principle that where there are two equally reasonable inferences that the jury could draw from the evidence, one that favors the defendant, one that does not favor the defendant, that neither version can be taken as proven beyond a reasonable doubt?
I don't think so. We're dealing with the required finding of the Lattimore standard. We look at the evidence in the light most favorable to the Commonwealth. And viewing this evidence in the light most favorable to the Commonwealth, the jury could make that determination that that was his intent and that was what he was doing. Now, that principle which Your Honor invoked, that's a very limited principle. And I think of the classic case, I think it was Commonwealth versus Salemi, where the victim who ended up being a homicide victim was seated in a restaurant between two other individuals. And then the waiter came in, served them, left the room. And then when he came back, the individual had been shot dead. We don't know who was the individual who did it, but the Commonwealth prosecuted and convicted one of them. And the court in that circumstance, wow, that's two equally persuasive explanations. It could have been individual A, could have been individual B. But ordinarily, that principle is not a good argument when we're looking at the evidence in the light most favorable to the Commonwealth. And here, the jury was entitled to draw the inference that based on the text and based on the prohibition in the restraining order, that he did this outside the terms of the exception. And unless there's further inquiry from the court, I'm willing to rest on my brief.
Seeing none, we'll thank you both and take this under advisement.
Thank you.
Thank you.
We are live. Thank you. Welcome to the Appeals Court. I am Justice Meade. With me on the panel today are Justices Sullivan and Sachs. With that, I'll call our next case, 2019 P710, Commonwealth versus Alvarado. Ms. Oren.
Thank you very much. Good morning. I'm Catherine Oren for Rogelio Alvarado. Quote, "Don't get distracted by comments regarding Mr. Garcia because it's not clean. It's not clean. This world is not clean," end quote. From the trial's first moments, the state miscast sole reason jurors were in court as dirty extension of gang warfare that included counsel, an evidence production he assured, and the crucible of cross-examination. In short, Alvarado's right to contest first criminal claims in his life. Far from dirty and unclean, trial comments offered a man who stood innocent as a matter of law sole means to disprove state claims that risked conviction for shocked self-defense. State closing, even worse, then serially denounced trial due process as the accused's chance at hearing the state's evidence before concocting lies in response. 4 times, it claimed changed Alvarado accounts born of trial presence, which was false, and assured distorted assessment of whether he truthfully reported shocked self-defense.
I'd like to follow up on that, Ms. Oren. This is Justice Sachs. I'd like to follow up on your second point, which has to do with the comments made in closing argument.
Yes.
The Commonwealth was essentially arguing that the defendant had sat through the trial and had tailored or had changed his pretrial testimony in order to fit what the witnesses had said at trial.
Well, he had changed his trial testimony. His pretrial statement to police had already been made.
Yes.
And so the claim was that he sat through trial and then he changed that account at trial to deceitfully in response to the state's evidence at trial.
Okay. So is it fair to say that when he gave his recorded statement to the MBTA police, he said words to the effect of, "I think I shot someone," or "I shot someone," and then?
Oh, he definitely, yes. He admitted that he shot Garcia during Garcia attack.
Okay.
And he admitted, he stated pre-trial and at trial, he never stated intent, though, to fire the gun, much less to strike anyone, even in self-defense.
Well,
and he admitted.
On the tape, he said, "I was forced to shoot him." Then he hears the witnesses, Alarcon and Aparicio, say that they saw the defendant going after the victim, Mr. Alarcon, with the gun, which makes it difficult for him to argue, "I was forced to shoot." And then the witnesses also say they never saw him actually shoot. So at trial, his story has changed from I was forced to shoot him to the gun just went off. He shot it 1 or 2 times. I never shot it except once at the top of the door. I didn't have my hand on the trigger. So aren't those changes that he made in his story, he told that latter story at trial in response to the testimony that he'd heard from the Commonwealth's witnesses?
Well, I mean, when he said forced to shoot, like he's set on, and everyone agrees that Garcia was the first aggressor here, and it would never have happened but for that attack. And everyone agrees, even Garcia. It was a fray once it started, and it was very confusing. He couldn't even say who first fired the gun, how the struggle had resumed. So when he says, "I was forced to shoot the guy came after me. He found me. He beat me down, and everyone agrees that."
But he didn't say that at trial. He said, "I never shot it except once at the top of the door."
Right, Sorry.
And the defendant says the victim Garcia shot it 1 or 2 times, and I didn't have my hand on the trigger.
Right. Well, but he does state that he concedes. He must have shot. It was in his hand, and he states he was simply beside himself. He shot up into the door frame of the car. The bullet fragmented, and Santos Alarcon was hit with a fragment, and it kept going off. He never denied. He never denied having shot the gun. What I'm saying is he never suggested either pre-trial or at trial, I pulled the gun, I went after the guy to retaliate and shoot him down because he beat me down. He never said anything like that. When he says forced to shoot, I was under attack, and during the fray, I definitely shot the gun. But it wasn't like retaliation. He was very clear at trial. I mean, I had the gun in my hand. I could have shot him down where it was, and that's not what I did. I was just so shocked that he was just moving in the moment.
Well, in his pretrial statement, he said, "I was forced to shoot." At trial, neither Alarcon nor Aparicio says, "I saw the defendant shoot the gun." So the defendant, hearing that, sees an opportunity to back off from his pretrial statement and change his story to the gun just went off. I only shot it once at the door frame.
Right, but I mean, he admits the gun was in his hand when it went off, and he was forced into the altercation, and so he never denied having shot it. I mean, it's just the question: was it intentional, or was it something that just happened in the fray, and he was just in shock and beside?
Well, it seems to me that at trial he did deny shooting it. He kept saying it just went off. I only shot it once at the top of the door frame, which is a change from which is. But isn't that a change from what he said? Excuse me. Isn't that a change from what he said to the MBT police on the recorded statement?
No, I think it might be investing the words "forced to shoot." Well, I'm under attack in the fray. Definitely, the gun was involved, and he never, even in trial, he's very clear. The gun was in his hand. He definitely shot it. The question is intent. He disputed intent to fire the gun, much less to strike anyone, even Garcia in self-defense. And that's what all that, he never denied having shot the gun. It's the question of intent. And when he said forced to shoot, I came under attack, and everyone agreed. An array of state witnesses, including Garcia, confirmed both his pretrial and trial accounts. So there really was unless I was forced to shoot, it would not be a rational understanding saying I was forced to shoot that I intended to retaliate against the guy. That's why I pulled it out and I shot him where he stood. No, he was under attack. Everyone agrees. And at trial too, the gun went off.
Well, let me probe that statement that everyone agrees he was under attack. Both Alarcon and Aparicio said that they saw the defendant pursuing the victim with a gun inside the subway car, which is not consistent with being under attack and is in a lot of tension with a self-defense claim. That is right, and that's where he's stressing.
He's beside himself. He's shot. He just came under attack. And everyone agreed that Garcia beat him down on the one end of the train. And then Garcia tried to take shelter behind other passengers in that car and moved away. And that's where Alvarado followed him away from the other passengers. And he stays stressed at trial, though. He was beside himself. And it's why the credibility inferences, why striking at Alvarado's credibility falsely is so damaging. Because even Garcia couldn't say how the struggle had resumed. And we know from everyone that Alvarado followed him away from the other passengers toward the other end of the car. But no one can say, even Garcia, how that struggle had resumed. And so it is consistent with shooting in shock. Even Garcia was so much in the fray, panicked and impaired memory. He couldn't state what
You're fading out a bit, Ms. Oren.
Oh, okay. I'm sorry. I'm trying to get equipment needed for future orals so that I can have regular Zoom. Right now, I'm just on my phone.
Just if you can keep your close to the microphone, might help.
Of course. Thank you. And so there really is no material inconsistency here. He was forced to shoot because he was under attack, and he was basically beside himself. And if he never suggested pretrial intensify that fact, much less in a retaliatory fashion, even against Garcia, even in self-defense. And that seems to be the claim here, and that's just not what he told Detective Leonard, the MBTA detective, before trial. And really the only potential inconsistency, it was pretrial, it was explained pretrial, and a Commonwealth expert confirmed the pretrial explanation from the stand. Alvarado had no criminal history. And MS-13 membership, you've got to have a criminal history and a specific violence one to boot. And that was the inconsistency. He explained it, though, pretrial to police. And the Commonwealth's own gang expert confirmed that logic later at trial.
He changed his mind at trial about his membership in MS-13.
He was very clear before trial with Detective Leonard that you have to have committed these crimes to be an MS-13 member. And he has no criminal history. We know that from his record. And that's the problem. You need not only a criminal history, but a violent one. And that's what the Commonwealth gang expert later confirmed on the stand at trial. So that was the only potential inconsistency, and it wasn't an inconsistency, much less a material one. And so the concern here is that the due process didn't stand a chance. The state weaponized the machinery, the rights of the accused, that the due process was meant to protect. And this reduced trial defense to a continuing gang attack, with Alvarado manipulating the letter of the law to relentlessly thwart its spirit. And again, falsity, bookended evidence so equivocal, even Garcia couldn't say who first fired that gun and how struggle had resumed on the under end of the car. And the problem is that state error exploited both primacy and recency at trial to wring conviction out of outrage and not dispassionate assessment of iffy self-defense proof. And on these grounds that Alvarado is seeking retrial of assault claims, not the gun claims. The assault claims are before the court by untainted fact finders.
You also focus on the comments at the beginning of trial.
Yes.
The prosecutor's opening statement.
Yes, that's right.
Do you have any issue with the part of the prosecutor's comment that said, this is a different kind of world, a world that is violent, a world that is difficult to understand, the world of gang life? Do you think that those were fair comments in the circumstances? I'm not asking you for the moment about the dark and dirty part.
Right. I mean, there is some case law where it's such a different world from the juror's experience. It would require an imaginative leap to assess the evidence. And you can't take things in isolation is the problem. The fact finders would have heard the whole opening statement. And it really does get very pointed where the Commonwealth stresses don't get distracted by comments regarding Mr. Garcia because it's not clean. It's not clean. This world isn't clean. Well, that's
so it's just the words it's not clean, it's dirty, it's dark. Those are the words that you
No,
have
no.
the
It's
issue
the
with.
question. Don't get distracted by comments regarding Mr. Garcia. That's trial defense. Every comment being made in that court of law about Mr. Garcia, that's Alvarado's sole means to contest first criminal claims in his life. And that included, don't get distracted by comments. Well, that's counsel. That's evidence production. That's the crucible of cross-examination. This is the machinery, the practical means we have of giving heft, substantive heft, to what would otherwise be nice thoughts or at best theoretical due process principles.
Excuse me, why isn't it not just the prosecutor pointing out how different the world is in gang life versus the poor commuters on that Blue Line subway train in the middle of the afternoon, that there's gunplay going on and people getting shot? There's no mystery that Mr. Garcia is in a gang, and as is the defendant. And this is not normal life on the Blue Line. And that's what the evidence, and that's what the evidence shows.
Right, but that has nothing to do with courtroom fact-finding. Courtroom fact-finding is inviolate. They've got nothing to do with gang warfare. This has to do with the
prosecutor gets to outline what his or her evidence is going to be, and the evidence showed that this was an assault by one gang member against another.
Right, and she says, don't get distracted by comments regarding Mr. Garcia because it's not clean. It's not clean. Any courtroom comments questioning Mr. Garcia, which is this is the guy who's claiming he was shot by Alvarado. He ended up being.
Before you run out of time, you'll agree now too, having read the Commonwealth's brief, that this was not preserved with an objection, right?
Well, it is. I mean, both the court and the counsel at trial believed it wasn't preserved. I think that's a mistake, and part of what I'm asking. Well,
the pages you cite, Ms. Oren, on volume 2, 42 to 43, there's no objection.
Right.
And
well, he does.
The attorney says there's no objection. The judge says there's no objection. Then the judge says he'll address it, and counsel agrees with that resolution of the matter.
Right, and that happened at the end of closing statement, where both court and counsel thought that counsel needed to get up and keep interrupting the opening statement every single time some improper comment was made.
That was the end of the opening, and there was no.
Right, that's right. And they're both saying there was no objection, even though he's saying right after the opening statement, he's essentially lodging an objection that the Commonwealth went way too far and the court agreed. And what they're both saying is that because he didn't get up over and over and over during the statement and interrupt it, the objection was not timely. And okay, that was their, that was.
I understand your response. Thank you.
Yeah,
I do have one further question about that interchange. Defense counsel said after the prosecutor's opening statement, I thought we had excluded that, but it's out. What is the defense counsel referring to there?
I don't know. I'd have to look at the transcript again.
He's talking about the dark world stuff, and then he says that he's going to address it too.
Which he does.
Right. I know he objected to it, and okay. I mean it was deemed untimely.
Are there any other questions?
I have to refresh my.
All right. There are no further questions. Thank you, Ms. Oren. Mr. Wakeford.
Thank
you. Good morning. May it please the court. I am, of course, Donald Wakeford, and I represent the Commonwealth in this matter. I wanted to begin with two points, which actually Justice Meade arrived at just before my time began here, which is that the issue regarding opening statements is not preserved. It's actually pointedly not preserved. And even if there was an attempt at preservation, the trial judge noted that a curative instruction, an instruction had already been given that opening statements were not evidence and would be reiterated at the end of trial, to which trial counsel responded, that's fine. I think to assert at this stage that this can still constitute an objection when it looks like there was actual consideration of whether to object or not, and then a decision not to do so is a bit too far afield. The other point I wanted to make is that the issue with regard to closing statements, I want to be clear that this is an issue with no constitutional dimension. It is solely an evaluation of prejudice. And we get that directly from the Person case that actually gave rise to this rule that the Commonwealth in most situations is not to refer to the defendant's ability to mold or change his testimony in response to the evidence at trial. But Person was decided on prejudicial grounds, not on a constitutional dimension. And U.S. Supreme Court precedent since then has actually found that comments like this do not have a federal constitutional dimension.
So what's your position on how the defendant tailored his testimony to what he had heard in the Commonwealth's case? What precisely did he change from what he had said earlier?
Well, there are some specific changes, obviously, to details which are given, but the primary thing, Justice Sachs, is that his entire justification, his entire explanation for the course of events changed from I shot someone because he found me and he forced me, to a litany of excuses for how the defendant actually never intentionally shot at anyone at all. And that is fundamental.
And how was that a tailoring to what the Commonwealth's case was at trial?
Because the defendant had heard two witnesses note that although he had told officers before trial that he had been forced and that he had no choice and had to shoot someone, he then saw two witnesses testify that he had pursued an unarmed man through a train car with a gun pointed at him. He also, as Justice Sachs, I believe you pointed out, had heard testimony that none of the witnesses actually claimed to have seen the defendant actually shoot the gun. So then he was able to say the gun, and I've listed these. I shot up, the gun fired, it just went off. It just went off, he repeats again. I didn't shoot Garcia, but I could have. I had nothing to do with that. My finger wasn't even on the trigger. And then finally, he said that, and this is another change, Justice Sachs, but he said before trial, he found me and he forced me. And then at trial, he admitted, yes, I did actually pursue him through the train car. So not only is it a difference in the justification that the defendant gave for his actions, but it's also a tailoring to account for the fact that, uninvolved witnesses saw him pursue an unarmed man with the gun. And since this is really an evaluation for prejudice, this is really a question about whether the prosecutor was within the permissible bounds of argument in pointing out these differences. And the differences between the justification here are certainly enough where the prosecutor was engaging in permissible argument to point these out to the jury and allow the jury to draw their own conclusions. Excuse me.
If we could, for just a moment, go back to the opening. I take your point on preservation. Can we agree that words such as clean and dirty were perhaps a little better left unsaid, given our general case law that we don't argue in an opening, and even in a closing, we stay away from generic characterizations?
I think that the trial judge certainly indicated on the record that he felt the choice of words went beyond a preview of the evidence. It's probably a best practice to avoid words like dirty when you're in an opening statement. And I think, though, what the prosecutor was attempting to accomplish was a preview of the evidence, and was, as Justice Meade indicated a few moments ago, a preview of sort of the abnormal circumstances of this shooting, trying to get a jury of citizens to understand how a shooting could occur in the middle of a train in the middle of the day. But I would agree that certainly the district attorney's office does not want to use words like dark and dirty lightly, particularly in an opening statement.
I understand, and certainly part of the defense was that Garcia was in a gang. There may have been tactical reasons why no objection was made in the opening or the closing, because arguments could be made about generic terms like that in a closing as well. But I take your point. Thank you.
And the evidence with dark and dirty was never targeted specifically at the defendant. It was not used to inflame the jury's passions or denigrate the defendant's character. It was to inoculate the jury from failing to feel any sympathy whatsoever for the victim of the shooting, the unarmed victim of a shooting in this case, Mr. Garcia.
Well, the defendant in some ways employed the same theme. I understand. I just was checking in. Thank you.
Thank you, Justice Sullivan.
What about the part that says don't get distracted by comments regarding Mr. Garcia? Couldn't the jury understand that as saying don't pay attention to the evidence regarding Garcia's conduct? We're here just to talk about the defendant's conduct.
At this stage of the trial, Justice Sachs, there had been a statement. Well, this is the very beginning of trial, and the expectation here was that the Garcia was going to be painted with the broad brush of 18th Street and the gang aggressor who had tracked down the defendant and attempted to attack him, and really was responsible for all of the violence within the train car. I think what the prosecutor was doing here was, by drawing in these references to gang life and the violent, realm of gang life, to try to get the jury not to be distracted by simply the gang associations that the victim in this case had. This is not a case where the victim was someone that perhaps most jurors could readily identify with because of his past gang associations. And I believe that's what the prosecutor was trying to accomplish by saying, don't be distracted by his associations to these other violent individuals or this gang association that he has. So I believe in that sense that it is a preview of the evidence and an exhortation to the jury to focus. In fact, I believe that's what the opening statement really was saying, was that this is the world we are in. This is the type of associations both the victim and the defendant have here. So I want you to focus on the evidence against the defendant and what actually the Commonwealth can show you in this trial. I also believe, just to sum up on the opening statement issue, there's no prejudice in this case because a fact I do not believe I included in my brief was that there was a voir dire question posed to each member of the jury about whether gang involvement or gang associations would make it impossible for them to discharge their duties, and of course got a negative answer from each person who ended up on the jury. That combined with the judge's instructions and the judge's real appraisal of the situation when he spoke with trial counsel that the instruction would be enough, or an indication that even if there was error here, which the Commonwealth does not believe there was, that there was not prejudicial to the defendant such that a substantial risk of a miscarriage of justice occurred. Finally, I just wanted to make one more comment with regard to the closing argument issue in the case that all of this comes from, Commonwealth v. Person. In that case, there was no evidence, and the SJC takes pains to point this out, no evidence whatsoever to support the prosecutor's statement that the defendant had molded or changed his testimony in response to the evidence that was heard at trial. And in fact, the SJC said in the Gaudet case that the prosecutor had baldly stated that the defendant had simply fabricated his testimony. So I think Person speaks to.
I'm sorry, Mr. Wakeford. In Person, he didn't make any pretrial statements, right?
That is correct, Justice Meade. I believe there was that was the SJC's point, that there was no evidentiary basis to make the assertion that the prosecutor did. And I believe that we are well outside of the situation that is rightfully condemned in Person in this case. Unless your honors have any further questions, I believe the Commonwealth's position on these issues is clear.
Seeing none, I'll thank you both, and we'll take this under advisement.
Thank you very much.
We are live.
Thank you. Welcome to the Appeals Court. My name is Justice Meade. With me today are Justices Sullivan and Sachs will be the panel for this case. Obviously, we're on Zoom. If we run into any technical difficulties, We'll try to remedy that as soon as possible, and each of you, if you are interrupted, will be able to still provide an argument. So don't worry if that should occur. With that, I'm going to call our next case. It's 2019 P1807 Commonwealth versus Martino. Mr. Maloney.
Thank you, sir. With the court's permission, may I begin?
You may.
Thank you, sir. Again, my name is Michael Maloney. Thank you very much for the opportunity. Your Honors, I represent Jose Martino. The issue, as articulated in the memorandum before the court, Your Honors, is whether or not the trial judge in Norfolk County incorrectly allowed the introduction of screenshots which had not been properly authenticated and thereby violated the best evidence rule. Your Honors, if I may just get right into it, I would suggest that the underlying issue here is whether or not the confirming circumstances which were grossly lacking in this matter were enough to legitimately authenticate and allow introduction said pieces of evidence, again, these screenshots. Without going into the facts, unless Your Honors would prefer I do so, I'll get right into the issue specifically. But as mentioned in the memorandum, the introduction of these screenshots were not cumulative. Essentially, these screenshots were used to further bolster the position of the alleged victim that Mr. Martino was in fact in a place at a time she relayed to the law enforcement trooper Paris. I'd like to point out a few specific issues. Again, there was no introduction that the, if I may back up here one moment, Your Honors. In regards to confirming circumstances, I would suggest that a litany of issues were lacking. Specifically, the owner of the phone, as articulated by the victim here, was never interviewed by police, was never a witness for the Commonwealth.
He wasn't in possession of the phone, was he, Mr. Maloney?
I did not hear your question, sir.
He was not in possession of the phone at the operative time. His sister was, right?
That is accurate, sir.
And the sister and the two participants in the phone conversation both testified, did they not?
That is accurate, Your Honor. Yes, they did.
All right.
And they both identified the conversation and timing as the phone, first the phone call and then the FaceTime video chat.
Well, sir, I would respectfully, time I think is subjective right there in regards to time, yes, but it did not have any date. The date was totally void. I would suggest that's a major differentiation, sir. A screenshot is a pretty easy item to manufacture. So when you say the time,
it says one screenshot says today. I think that's from the victim's phone, and I believe the other screenshot says yesterday. That's from the friend's brother's phone that the friend was using to call the victim. So although they may not have dates, don't today and yesterday sufficiently locate them in time, given the police officer's testimony about when he interviewed both of those witnesses?
Sir, I would suggest that they simply fall short of the best evidence rule. I understand that today and yesterday, given additional
Mr. Maloney.
I'm sorry, sir.
Mr. Maloney, we've held that the best evidence rule does not apply to digital media because there's no original to produce.
Understood, sir. If I may continue down that path, sir, again, there was correspondence between the alleged victim and the first complaint witness. The screenshot that was actually produced at trial was actually a screenshot that was produced by the first complaint witness and in turn sent to the law enforcement. So again, I understand that best evidence may not apply in regards to the digital media, but I would suggest that this takes it even a step further. In that it was a screenshot that was sent to someone else that was thereby introduced when the person that the phone belonged to, this individual's name was not actually said in the printout of the screenshot. He's referenced by a moniker, so to speak, Taquito.
Let me see if I understand your argument. Are you saying that the owner of the phone had to authenticate this, or
I'm not saying that the
internet service provider had to authenticate this? What precisely is your argument?
My argument, Your Honors, is not that any one step should have been taken in lieu of others, but that some steps, something to corroborate this should have been done. There was no
Like
evidence.
what?
I'm sorry?
What are you saying should have been done specifically?
There was no an investigation, Your Honor, an investigation or some sort of good faith showing by the district attorney's office to show that efforts were at least put forth.
That's not my question. For purposes of authenticating the document in court, who are you saying should have been brought in to authenticate the screenshot?
The brother.
The brother who was not on the phone at the time that the phone calls and FaceTime calls occurred. What competent evidence does the brother provide?
The brother who went by the nickname Taquito, Your Honor, Taquito was referenced in the screenshot. There's no confirmation that this was a password protected, that anyone else had access to this name, that someone else could have been using the phone.
Someone else was using the phone. The sister was using the phone, and she testified that that was his nickname.
Yes, Your Honor.
I had understood that you were saying that some internet service provider needed to come in, but you're saying it was the brother.
Your Honor, again, I think there would have been a litany of ways where this information could have been corroborated, whether it be the confirmation via business records from the phone company, or confirmation. This is an evolving area of law. I understand that, and I realize that this court and the SJC have grappled with this issue in regards to what actually can be utilized to confirm or to, confirming circumstances. And I would suggest that the Commonwealth failed in this regard to support any confirming circumstances, whether it be the brother, whether it be the phone records, whether it be confirmation of the nickname, whether it be failing to corroborate that it was actually password protected. Your Honor, this is to get into the essence of the case.
Well, before you go there, let me just see if I can rephrase your argument and see if I understand you correctly. You're saying the fact that the two participants in the conversation and the FaceTime conversation testified are insufficient confirmatory circumstances.
That is accurate, Your Honor. Thank you. Okay. Yes. If there are no further questions, Your Honors, I would leave it at that, but I do welcome questions and thank you for the opportunity.
Seeing none, thank you. Ms. McLaughlin.
Good morning, Your Honors. Should I just wait? Good morning, Your Honors. Assistant District Attorney Laura McLaughlin for the Norfolk District Attorney's Office. The Commonwealth submits that the defendant's conviction should be affirmed. The judge did not abuse her discretion in finding that photographs memorializing a video call and phone call were authentic, where both the victim and first complaint witness testified to the calls being both made and received. There was direct evidence through their testimony that the photographs were authentic. In addition to the direct evidence, there was also confirming circumstances. The Braintree police detective observed the call log on the victim's phone. He also received a copy of that directly from the first complaint witness. The first complaint witness brother is not necessary to authenticate the photographs. He was not involved in any of the phone calls. Further, the rules of evidence do not require exclusive access, is not necessary to authenticate a piece of evidence. In addition to both the direct evidence and confirming circumstances, the victim and first complaint witness testified they were subject to cross-examination on any perceived inconsistencies. Further, the defendant was not prejudiced. The timeline of the incident was established through the defendant's own testimony. Any inconsistent statements about when he left the apartment were subject to the jury to assess credibility of the evidence. And further, it was the defense counsel who called into question the timing of the calls through his cross-examination of the victims, as well as the first complaint witness. Unless there's any further questions, I respectfully rest on my brief and respectfully request this honorable court affirm the defendant's conviction.
I have a factual question. Perhaps I misunderstood what Mr. Maloney was saying, but I thought it was the victim's phone number was saved in her friend's brother's phone under the name Taquito.
Yes, Your Honor. That is correct. There's no evidence, as defense counsel has claimed, that the brother's nickname was Taquito. In fact, the first complaint witness testified that the victim's phone number was saved in her brother's phone under the name Taquito, and the victim testified that the brother's phone number was saved in her phone under the letters E-A-L.
Okay, thank you very much. Seeing no other questions, we'll thank you both and take this under advisement.
Thank you, Your Honors.
Thank you very much, Your Honors. Have a nice day. Be well.
Thank you. You too.
We're live.
Thank you. Welcome to the appeals court. My name is Justice Meade. With me this morning are Justices Sullivan and Sachs. They'll be the panel for this case. As you can see, one of our attorneys is on the phone and on video. We had an audio problem and we have resolved that. With that, we'll call the next case. It's 2019 P34 Commonwealth versus Oliveria. Mr. Stachecki. You have to unmute yourself. You're muted.
Good morning, Your Honors. My name is Attorney Carl Suchecki, and I represent Mr. Oliveira. In this case, the Commonwealth has sought to introduce and to expand the record in regards to trying to prove that Mr. Oliveira received notice, even conceding that this should have been done at the trial court level at the motion and during the motion hearing, and it's not the appeals court business to take in evidence. Even if the court chooses to look at it for edification, I would urge the court to look at the form. It looks as if the form was done contemporaneously with the notice given to them that they had lodged a detainer. The form has a spot on the very bottom of the form that has a spot for my client's signature. There's no signature on the form. There's no date on the form. So it's just as conceivable that my client never got notice and that this was just generated by the administrative person who handled the detainer, and that these forms are done contemporaneously and notice was not received by my client. So one of the first issue in our case is a speedy trial issue. And our point is, the first one is under Rule 36. The Commonwealth should have given my client notice of the speedy trial rights, and they did not do that. My client did not receive notice until almost 3 years later.
But this is the Rule 36D3 argument?
Yes, Your Honor.
But that was not made to the motion judge.
Correct, Your Honor.
So it's waived.
Okay, well, even if that argument is waived because it was not raised during that hearing, it doesn't waive the constitutional violation, which is
that's true.
Barker v. Wingo analysis. The first thing we look at with Barker v. Wingo is the length of the delay. The delay was 3 years and 11 months. So that kind of opens the threshold, which would have opened the threshold under Rule 36. The reason for the delay, it appears to be neglect by the Commonwealth, or a desire just to have the detainer and at their leisure prosecute my client.
I think that's what the motion judge found. It was negligence. There's no evidence of the Commonwealth deliberately trying to delay this, right?
Correct, Your Honor. They're not on the record.
And your client doesn't assert his right to a speedy trial until January of 2016.
Correct. And that's because
that's quite a long wait. So that I think the case law says that weighs against him, right?
But no, not at all, because that's not his fault. The reason he didn't get notice until 3.5 years later. That's not his fault. That was on the Commonwealth.
Well, let me ask you this. If there's evidence in the record from which the judge could conclude that he learned of the detainer in 2012, then that's a 4-year delay in him asserting the right, or 3 years, 11 months.
But there's no evidence in the record that supports that. There's no evidence that supports that. It's
Well,
just,
they did send the detainer,
yes,
and under the interstate agreement on detainers, the defendant is to be notified.
right.
And then at the very least, in 2013, the defendant gets resentenced on his federal case, right?
Correct.
So he would have been aware at resentencing that at the latest that there was a detainer lodged against him.
I don't think that's a valid supposition. I think that what you have is even the document they want to include doesn't prove anything. It just says that they lodged a detainer. That was already in the record, and that was proven. But the fact that his notice is not proven, there's a spot for him to sign. It's not there. So
The notice of the detainer action that was sent back to the district attorney's office was copied to the defendant and or inmate, as it said on the paper, and does include a recitation of the 5 aggravated rape charges. So can't we presume that the inmate got a copy of that?
Yeah, I would assume nothing, Your Honor, based on the fact that, especially since that document that they want to expand the record with proves that just the opposite, that there's a spot for my client to sign and there's no sign. So the delay is not his fault. It's on the Commonwealth to prove it. And they can't, you're past that right, that requirement on to West Virginia. It's their responsibility to give my client notice, and they didn't. And there's no proof that they did. So
I was interested in the wording of the defendant's affidavit where he says, when my sentence was about to end, I discovered that there was a warrant out of Brockton Superior Court. He never says I was unaware of the charges until my federal sentence was about to end. He says something about a warrant. So I mean, that omission is suggestive.
I think that you're still looking to make assumptions which shouldn't be. You should have the record, and it's their duty to prove that he got notice, and there's no record whatsoever. And I again say that the document they want to include in the record proves just the opposite.
Well, if he hadn't received notice, wouldn't it be natural for his affidavit to say so?
I wasn't there for that. I don't know. I don't know whether it was cleverly worded or not. I do know that what's on the record, and the fact is that the proof of notice is not on the record. And then
doesn't in Wallace, doesn't the SJC tell us that the Commonwealth need not affirmatively prove that he was aware of the charges for the delay in asserting the right to weigh against him?
But it's still not my client's responsibility to prove otherwise. I mean, it's their duty to give him notice. And if I may, I move on to the prejudice that
I think you should go ahead.
Was that my client, attorney's affidavit says that he was unable to get affidavits or unable to get witnesses, and the particular counselor who examined the complainant said that she had no memory of it because it was 4 years prior.
Two things, Mr. Stachecki. The counsel's affidavit doesn't identify who these witnesses were or what they would say, and he doesn't have an affidavit from the social worker.
That's on the record, Your Honor. I can see that's true, but that doesn't necessarily mean that that's not the case.
Well, no, what it means to me, unless you tell me otherwise, that the idea of prejudice is based on speculation.
Not necessarily. In our brief, there's case law that says that you can presume prejudice if the defense is with the delay, that their witnesses are going to obviously forget things and be less available.
But the social worker said she never kept contemporaneous notes anyways. So there's nothing, in other words, there's nothing in the record that demonstrates that her lack of memory was based on the delay or her not taking notes.
Well, I think that's just common sense, Your Honor. 4 years later, people forget things, and she obviously forgot and says that she forgot the very interactions with the complainant. You know,
the classic case on presuming prejudice in these circumstances is the Doggett case, which I think you cite in your brief. It's from the United States Supreme Court. Mr. Doggett never knew for a decade that he had been charged. And they said, and that's where that justified a presumption of prejudice.
I think with 4 years, you can presume prejudice, Your Honor. I think that memories are going to be gone after 4 years or distorted. Our second argument.
The social worker didn't testify at trial, did she?
No, Your Honor. So our second argument was an abuse of discretion by the trial judge to allow in two statements by the defendant, two very prejudicial statements. I note that the Commonwealth says in their brief that the relationship between Ms. Fischetti and Mr. Oliveira ended in 2007. These statements that were allowed in by the trial judge were made in 2008. Those statements presumably were made to Mr. Oliveira, or Mr. Oliveira made the statements on the telephone from federal prison. Now, if the Commonwealth wanted to introduce those statements, they should have introduced tape recordings that proved their point. These particular statements, and I don't necessarily want to repeat the first one, which was involving calling the counselor something and the complainant something, were with no context. They came in with no context and were deliberately designed to inflame the passions of the jury against my client, because there's nothing else from it. The judge said it shows state of mind, and then makes the assumption that because of therapy, that the complainant necessarily may make a revelation. But we don't know if Mr. Oliveira has some kind of dealings with the psychologist before, or has some kind of problem with counseling, or it's just, there's no context to it. So it was error and abuse of discretion to allow that.
Why didn't the statement of whether it was provided from the Federal Board of Prisons or from the victim's mother's testimony, that's just an issue of credibility. But assuming that the jury gave weight to it, why doesn't it show the hostile nature of the relationship that the defendant had towards the victim, and the very idea that she was getting counseling after she was shutting down in a time very close in time to when the rapes occurred?
Well, I'd say it doesn't necessarily prove that, because it's out of context. There's no context that they're not talking about, maybe they had a conversation about counseling in general, or they don't believe in psychiatrists, or it's just out of the blue, and it's a very hostile and it's very damning. And it doesn't, I don't know how it shows a nation of relationship when
the judge also said it evidenced consciousness of guilt, and didn't explain why he would say such a thing unless he was making an admission.
I would disagree that there's nothing to it as far as admission. It's made 3 years before the first complaint, and it's after the relationship broke up.
But the victim said she'd been raped over many years.
I don't understand what the point in that is.
That it was contemporaneous to the alleged rapes. That it wasn't out of time.
I'm not following. My point is that the statement allegedly made by my client was in 2008, and the fact that she's going into counseling and he has an angry reaction to it has nothing to do with the case at bar. It is nothing at all. It's out of the blue, and it's very prejudicial. The second statement I want to get to is far more prejudicial, and it should not have come in as well. And again, the relationship ended in 2007, and then the Commonwealth tries to claim that the statements that he didn't rape her, assuming it's my client, the complainant, and that if Ms. Fischetti tells or takes him to court, he'll kill her. Now, it's directly on point, but it has nothing, it's completely, again, out of the blue. There's no context for it. And it's unfathomable. And the
context is that the defendant is concerned that he's going to be accused of rape. He blames it on his brother and says that if you go to court, I'm going to kill you. That's quite clearly his consciousness of guilt.
But, Your Honor, it's 3 years before the first complaint. And he's telling the mother this 3 years before the first complaint. And the judge
how many years before the first complaint did the victims testify that the rapes began?
I don't know the answer to that, Your Honor.
Many.
But the point being that I lost my point. The long and short of it is these statements came in, and the killing and that he didn't rape her was 3 years before. Now, and this is where my point was.
Well, isn't the very point? Isn't the point that that kind of statement, if the jury credited it, would be one reason why it took so long to have a first complaint?
No,
and isn't it all relevant statements are prejudicial to one side, to the side, the party against whom they're admitted. The question is whether or not the probative value outweighs the prejudice.
Well, the prejudice is far outweighed by the probative value in this, and particularly because, and the judge says this when he entertains the motion in limine, he says, well, it's really, if the mother heard this statement in 2008, did she go to the complainant and ask her if this guy was touching her? And she didn't know the answer to that. I mean, this is 3 years before. It's unfathomable that a mother hears that her daughter was being raped, even if it is, her former boyfriend or his brother, either one. She should have gone to her and asked her if in fact that was true.
We also, Mr. Strzecki, we also have the testimony of the defendant's friend, Jimmy, who walked in and saw him in bed with the naked 12-year-old when they were living in Carver.
That's not true. She was not naked. She was in shorts. They're in the same bed, and it's not it happens with parents sleep in the same situation as them. I'm not justifying it, but I'm just saying in context that that's factually incorrect. So the fact is, if that statement were true, she would have gone to her and asked her. And the fact that these statements came in was more prejudicial than probative. And for the rest of my arguments, I'd rest on my brief. Thank you.
Thank you. Ms. Middleton.
Thank you. May it please the court, Bridget Norton Middleton for the Commonwealth. The defendant is appealing his convictions for 2 counts of rape of child with force. He was charged with 5 counts. The jury came back on 2. The defendant, as we've heard from my brother, was the live-in boyfriend of the victim's mother. The victim was 9 years old the first time the defendant raped her. The rapes continued for the next 6 years. The defendant raises 3 issues on appeal, 2 involving denial of his speedy trial rights, and 1, the admission of his statements. If it pleases the court, I would start with the Rule 36 arguments that the defendant made. As I've indicated in my brief, the defendant has raised at least 3 issues on appeal for the first time, and I would ask the court to deem them waived. The first is the court discussed with my brother was the violation of Section D3, which requires the Commonwealth to notify the defendant of the charges and his right to a speedy trial after the filing of a detainer. As I said, the defendant did not.
Did the judge rely on D3?
No. In fact, the court didn't make any findings on D3, and I would point out that the Commonwealth, in their response below, dropped a footnote clarifying the defendant is not raising D3.
There's a reference to D3 on page 2 of the judge's decision.
I don't believe that the judge relied on D3, and also I would say to the court that defense counsel mentioned D3 in his argument before the judge, and that was a response to the Commonwealth's footnote indicating that the defendant had not raised D3, which also I think points to the.
Unless I'm misreading it, I think there's a. Go ahead, but I think D3
Sure.
is quoted. I mean, let's not tarry long over this. If the judge did rely on D3, and we can all look at that later, is it still? Would one consider the argument to be waived?
It's Commonwealth's position that the defendant did not raise it below, and the reason why it would be waived is that the record is not developed here, and there is the motion to expand that the Commonwealth filed. The reason why Rule 13 requires you to put things in writing is so that the Commonwealth has a fair opportunity to respond to the defendant's motion, and to the judge can develop the record, and then when we come up and appeal, the documents that I have in my motion to expand are part of the record. Obviously, the Commonwealth would have requested these records. I would say this, though, that assuming that the judge does rely on D3, I think there's enough in this record for her to show, at least in the piece where did the defendant know about this, is one of the justices indicated there's a copy at the bottom, even on the records that the defendant put in his motion, where there's a copy of the detainer action letter from DOJ is copied to the inmate. But the D3 argument is a little bit more, you have to show that the Commonwealth advised the defendant of his rights to a speedy trial and the charges against him. And the documents that the Commonwealth has provided in my motion to expand speak to that the Commonwealth didn't in their letter advise the defendant of his speedy trial rights, but the facility in West Virginia did. And under the case that I cited—
Excuse me, counsel, on what basis would we take those documents for the first time on appeal? Okay, can you give us authority for our ability to do so?
So I've argued in the alternative, and my argument would be this, Judge, and Justice, I understand the question, is that I would ask the court to deem it waived. If the court is not going to allow my motion to expand the record, then I would ask the court to remand it to the trial court for further findings on this particular issue.
Okay, even if waived, do we review for substantial risk? Some of the cases that you rely on waiver argument, if you trace back to pre-Randolph precedent.
Right.
And if we have to review the constitutional issue anyway, would that not subsume the substantial risk analysis regardless?
It would. I think if the court reviews it on a substantial risk, the Commonwealth meets its burden and the judge made the proper ruling on the motion. The other two issues that the defendant raises for the first time in appeal is he's challenging the time period from his Rule 36 motion to his trial. I would direct the court to the defendant's record, page 34, where his motion below to Judge Kelly, and he lays out the time period that he is challenging, and it does not include that time period, so that would be waived. And also, for the first time on appeal, the defendant is claiming that because there were two dockets here, and that the detainer action letter, two sets of indictments, and that the detainer action letter references the second set of indictments, therefore there is no detainer here. The defendant did not make that point to the judge below. She didn't make findings on it, although he criticizes her in his opinion. The court should deem that argument waived, but in any event, I would just point the court to Article 5D of the IAD. And Article 5D of the IAD indicates that detainers that state that a defendant may be tried on charges arising out of the same transaction. And I think it's clear from the evidence before Judge Kelly, the Commonwealth provided a copy of their null pros, that these were identical two sets of indictments, and the Commonwealth indicted on the same conduct in two different ways because it was a change in the law. And by the time they came to trial, they realized they couldn't charge the defendant with the aggravated 10-year felony, 10-year age difference. So turning quickly to the claims the defendant does raise the remainder of them on Rule 36. One is 36B, which requires the defendant to be tried in 12 months. That doesn't apply to a defendant being held outside the Commonwealth. And then Rule 36C, which is kind of a catch-all dismissal for prejudicial delay. And what the defendant would have to show is that the Commonwealth unreasonably was lacking in diligence in bringing the defendant to trial, and that the conduct prejudiced the defendant. On this record, there's no unreasonable lack of diligence by the Commonwealth. Here, the Commonwealth issued 2 writs to the Plymouth County House of Correction within weeks of the defendant being indicted to seek his attendance for his arraignment. Within 5 months of the indictments, the Commonwealth had lodged a detainer in West Virginia. And I would also point to the court to Article 3 of the IAD. Once the Commonwealth files a detainer and the defendant is notified of that, the IAD puts the ball in the defendant's court to notify the Commonwealth that he wants to be returned to Massachusetts and be tried on these charges. In terms of prejudice, the defendant points to the records of Diana Barboza, who was a social worker who spoke to the victim I believe in 2008. The defendant claims that he was prejudiced because he had trouble obtaining her counseling records, but The record supports the motion judge's finding here. There was no affidavit from Ms. Barbosa. The defendant did not show that she forgot anything. What it indicated is that she didn't remember, she didn't write things down. She didn't indicate that it was the 4 years, or at least his affidavit didn't even make the claim that it was the 4 years that made her forget. The defendant failed to show the, strike that. And then I would also point out that here the evidence consisted of trial testimony of witnesses. All the named witnesses appeared and testified. The defendant does not point to any named witness who he could not locate or call in to testify. And the delay here actually hurt the Commonwealth. We had a young victim, a sickly mother. The defense attorney cross-examined them both quite extensively with their inability to remember certain details. He argued to the jury that, well, who else didn't testify? So here the delay, it's one of the cases I think where the delay hurts the Commonwealth, and the defense attorney at trial was able to effectively use that to undercut both credibility of the mother and the daughter. So in these circumstances, yes.
I'm sorry to interrupt. As you illustrated, is so often the problem in a case that takes so long to try with a young victim. Why did the Commonwealth delay this matter?
The Commonwealth didn't delay this matter. The defendant was being held in custody in West Virginia.
Could they not have obtained him while he was serving his federal sentence to be tried here on those charges?
Well, that's why in part of my brief, I indicate to the court that, first of all, the record is silent on that, what we have before us, but I would indicate to the court that even with the documents that the defendant provided to the court, there is a resentencing of the defendant in 2013. And cases I cited in my brief indicate that it's not clear that the federal authorities, that the defendant in those circumstances, why was he resentenced? What was the status of his federal conviction in the meantime? And could the Commonwealth even have secured his attendance under the IAD if he wasn't, quote, serving the sentence? So I think that is something that adds into the delay in time as well.
Okay.
But I would also say that the IAD does put, once the Commonwealth has notified the defendant of the charges, the IAD puts the ball in the defendant's court to come back and be tried on the charges.
Just for the students listening, by IAD, you mean could you say what that is?
Yeah, it's the Interstate Agreement on Detainers. Thank you.
Does the record tell us when the counseling with Ms. Barbosa began and when it ended? I couldn't find that.
There was testimony from the mother indicating that and testimony at trial that the victim tried to kill herself in 2000 or wanted to kill herself in 2008 and was hospitalized. And I believe that it's contemporaneous with that, and that's when the phone call with the defendant takes place. That's the impetus for the phone call, that she puts herself in a hospital, and then the mother calls the defendant. I believe he's in federal custody, which is something the judge didn't allow the jury to know, and speaks to him about the counseling, and that's when we get into the statements of the defendant.
So it may have started in 2008. Do we have an indication of when it ended, or whether it ended?
I don't believe we do from the record, but Justice Sachs, but I could check that.
So for all we know, it could have been continuing at the time of trial?
The record is silent on that. It could have been. So then we turn to the defendant's Sixth Amendment and Article 11 claims to a right to a speedy trial, where you do the four factors in Barker v. Wingo, and some of this is repetitive of the Rule 36 analysis. Initially, one of the first factors is the length of delay, and is it long enough to trigger an analysis by the judge? And Judge Kelly found that here it was an almost 4-year delay. The reason for the delay, as I've discussed, is the defendant's fault. The defendant was notified, he was copied on the detainer action letter and did nothing. And I think that this is one of the cases where the defendant is trying to fly under the radar. 2008, he knew about these allegations, at least factually from the mother, enough for him to deny them. 2012, there's a detainer action letter where he is aware that he's been charged with 5 counts of rape of child by force. The longer the defendant waits, the better off he may be. And as I indicated, he effectively used that delay at trial. The third factor that the court under Wingo is the defendant's assertion of his speedy trial rights. The defendant waited till 2016 to assert his speedy trial rights. And the last one is prejudice from the defendant, which we have discussed in terms of Ms. Barbosa's record. The defendant can't meet his burden of showing that he was unfairly prejudiced by this evidence. That would leave the third issue is the defendant's statements to the victim's mother. Here, Judge Locke carefully looked at these. He weighed the probative values of these. These were relevant statements, and the probative values of these statements did not unfairly prejudice this defendant in these circumstances. And I would point to three areas where these statements that the defendant made to the victim's mother were relevant. The defense here was that the victim was a troubled girl who fabricated these allegations against her mother's boyfriend as means to get back at him because she didn't like him and to protect her mother. The defendant used the victim's delay in reporting and encouraged a jury to speculate, that she's not credible because she has delayed in reporting and she can't remember things, and then speculate who else did she tell. So in those circumstances, the idea that the defendant in 2008 had knowledge of the rapes and showed his hostility towards the victim, the mother, and the idea that she would get counseling undercuts the defense theories of a recent fabrication by this victim. Also, there was Commonwealth needed to prove the element of force, and here it was constructive force. And evidence of the defendant's threats against the mother, his hostility towards the victim, which the victim testified was a factor in why she did not resist the defendant and why she had a late disclosure. So in that light, the evidence of the defendant's threats and his hostility towards the victim is relevant on the issue of constructive force. And then finally, as the trial judge found, the statements here were relevant to the defendant's state of mind and his consciousness of guilt. And the defendant is threatening a witness in the case. So I think in these circumstances, Judge Locke did not abuse his discretion in admitting the statements. And I would just also argue to the court that assuming that you did find there was some error in here, was this defendant prejudiced by the admissions of these statements? And I would point to a couple of things. The jury acquitted the defendant here on 3 charges. He was charged with 5 counts of rape of child. They acquitted him on 3. So I think that's some indication that the jury was not unduly swayed by this evidence coming in. And also, the Commonwealth here had a very strong case. Unlike a lot of cases that we see with a young child rape victim, we had an eyewitness in this case. The defendant's 30-year friend, Jimmy, who lived in the house in Plymouth, lived in the apartment in Carver, and strongly corroborated what the victim claimed. In terms of the Plymouth house.
We're going to have to leave it at that, Ms. Middleton. Your time is up.
Thank you.
Thank you very much. Thank you both. We'll take this under advisement.
Thank you.
Thank you.
116 Commonwealth versus MARRERO-MIRANDA. Mr. Dreschler.
Good morning. May it please the court. Justin Dreschler for Antonio MARRERO-MIRANDA. Your Honors, this argument is essentially an argument about a statement, as you can read in my brief. There's one primary argument, 2 prongs to that primary argument. This is the statement of Ms. Shaw, or CG. I don't know which which pseudonym the court prefers, but it's her statement to the EMT that she was forced to the ground, shoved to the ground, and had her vagina penetrated with Mr. MARRERO-MIRANDA's fingers, or what we assume was Mr. MARRERO-MIRANDA's fingers. The argument's 2-pronged. One is that this didn't qualify under any exception to the hearsay rule. So as you know, this was substantively admitted at trial through the EMT who Ms. Shaw made this statement to. And essentially the hearsay argument regarding the excited utterance, if you take a look at the circumstances surrounding it, Ms. Shaw's crying, she's shaking uncontrollably. It's actually not that far in time from when the incident happened. And so on its face, you look at it and say, oh, well, clearly it's a spontaneous utterance. There's no question at all. But it's actually a much more unique circumstance than that, because what you have here is you have a situation where you're really testing the reliability of the statement. And the entire foundation of any hearsay exception, but certainly the spontaneous utterance exception, is this idea that it's reliable. And in these circumstances, the statement was actually made in a quite unreliable manner and in a quite unreliable context. You have Ms. Shaw having 10 to 15 minutes with Officer Douge, where she's sitting on a step with her, doesn't say anything to her about a sexual assault, nothing at all. In fact, says the exact opposite. She says, I'm not here against my will. He didn't do anything against my will. And actually, that is an important distinction. And I want to—
Mr. Dreschler?
Yes.
The victim testified that she was not in the alley against her will. She did not say that she consented to the sexual assault.
Well, I think, Your Honor, there are actually two different points where they talk about sexual assault. I know the Commonwealth made that point in its brief, and I didn't appropriately or adequately address it in my reply. On cross-examination, if you actually look at transcript, volume 3, page 16, Attorney Whalen, when he's crossing Officer Duge about the police report, specifically asks, she told you that he had not done anything against your will. Had not done anything against your will. And so that is actually the phrasing. And it's in a context in the transcript where he's reading word for the police report. He actually says, quote unquote, hadn't done anything against her will.
Does the statement to the EMT say he did something against my will? Does it contradict what the victim said to Officer Duge?
I think it does because of the force that's implied, not even implied, but stated, that she's grabbed and thrown to the ground, that she's pushed against a wall, thrown to the ground, and then his fingers penetrate her vagina. I think if
does the victim even identify the defendant as the man that assaulted her?
She doesn't. She isn't really able to do much of anything. But again, contextually, she's found in the alley with another man. I don't think there is any question as to who she may have been referring to. Now, she may not have been able to say, this is what he looked like, and this is, what his name was. But certainly when she's found in an alley with someone on top of her and that man is 10 feet away from her in handcuffs, the implication is quite obvious.
Just going back to the statement that she made on cross, the motion in limine that admitted this statement was allowed before the testimony of the EMT on cross that, I'm sorry, was it the EMT or, yeah, that it was before the EMT testified at trial on cross-examination that the victim had said defendant hadn't done anything against her will. So if that's the basis for keeping out this statement because it's the product of reflective thought and not an excited utterance, didn't the motion to strike or an objection have to be lodged again at that time?
I don't think so, Your Honor, because I think the law is clear that as long as you make clear in the motion in limine what you will be challenging and the basis under which you will be challenging it, a later objection isn't necessary. I think it's
right. But when another ground for objection appears later, which is what this statement on cross is, you're saying, doesn't the objection have to be renewed at that point?
I'm not sure there is another ground because Attorney Whalen is bringing up something that's in the police report. And so this is something that was argued in the motion in limine. So this is this was argued pre-trial, the anticipated testimony. I think it came out a little sloppy on direct, frankly, Your Honor, because the actual quote that he is quoting from the police report is done anything against your will. It's not here against your will or anything along.
Police report?
Pardon me?
Where is the police report?
Police report's not in the record. The police report wasn't introduced at trial, obviously, but you can
is
see
there testimony about the police report?
When Attorney Whalen is crossing, he is talking about the police report, and you can see, and again, he says in this passage, quote unquote. And so this is him talking about what Officer Duge memorialized, because so much of his cross-examination had focused on like, well, you didn't memorialize this and you didn't memorialize that. Again, with Viviana Perez, his focus was on that. And so he focused quite extensively on the police report and why certain things were missing from that police report and other things were not missing from that police report. No.
And was the police report discussed at the voir dire of the EMT?
Your Honor, I don't want to say one way or another without having a definitive answer. So I don't know if the actual police report was referenced, but the anticipated testimony could only have been based on the police report, I suppose, grand jury testimony. But the statement that nothing had been done against her will is only found in the police report because Ms. Shaw never says it again. She really doesn't say anything about this situation. And so I would say, no, I don't think that an additional objection needs to be lodged because it was very clear what they were objecting to. I also, Your Honor, I do think this idea that she wasn't in the alley against her will, I do, despite the fact that I do think there's additional evidence that she specifically said he didn't do anything against her will. I think when taken in the full context of the question being asked by Officer Douche to her that it would be understood to mean, were you here, did you consent to any sexual activity with this man? I think in the full context that is a fair reading.
I also think it's probably understood or should be understood that someone with that level of alcohol in their system was incapable of consenting to anything.
That's certainly a possibility, Your Honor. That's I think that is an argument that could have been explored at trial, an argument that I think the Commonwealth, I think they did hash that out a bit at trial, because there was some confusion as to whether Mr. Whalen was actually arguing that there were issues around alcohol and whether that provided a defense on one side or another. And is the
defendant not on video touching the victim's crotch and her slapping his hand away?
He is, but the defendant was convicted of multiple counts in this case, for one. Number two, I don't think that video definitively proves anything. I think
it corroborates her statement to the EMT, though.
It doesn't. To the EMT, she's talking about being thrown against a wall and thrown to the ground. She doesn't reference what is happening in that alleyway, which is nowhere near.
I thought she said that he put his fingers in my vagina.
She did say that, but she said it in the context of he pushed me against a wall, then he shoved me to the ground.
And does the video not at least depict him putting his hand in her crotch?
Yes, but not at all in the context of any sort of use of force, of pushing her to the ground, of throwing her against the ground. And also, certainly don't want to claim that video is exculpatory from Mr. MARRERO-MIRANDA, but I think, just as Attorney Whalen did, that the video can be seen and interpreted in a number of different ways. And there are a number of facts in that video that are actually quite favorable for Mr. MARRERO-MIRANDA, including Ms. Shaw's body language, the fact that she's not actively running away, the fact that she turns when he calls to her. But in any event, I think this discussion probably goes to the issue of whether there's actually prejudice in this case. And here, given that the standard that we're reviewing under, at least with regard to the constitutional error, is harmless beyond a reasonable doubt, regardless of whether the Commonwealth was able to present some evidence of sexual assault, and I will freely admit the Commonwealth did present some evidence of sexual assault. They've got the 911 calls, they have Ms. Shaw saying, no, stop, things along those lines. But this statement is such a key part of evidence. This statement is essentially her saying, I was sexually assaulted. And it's being juxtaposed with a statement where she says I wasn't. So,
can we talk about what the Confrontation Clause standard is? Your brief cites the Gonsalves standard from, I think, 2005 of the proper inquiry is whether a reasonable person in the defendant's position would, or in the declarant's position, would anticipate the statements being used against the accused in investigating and prosecuting a crime. Hasn't that been superseded, as the SJC recognized in the Imbert case and the Wordsworth case in 2018, 2019, by inquiry into whether what the primary purpose of the statement was in determining whether it was testimonial?
Well, I think regardless of the standard that we're working under, Your Honor, the primary purpose or the testimonial and fact standard, we're dealing with a situation where it clearly implicates the Confrontation Clause. So when we talk about the Confrontation Clause, in this situation, so we have to think about it again in the full context. The full context is so important here. So Ms. Shaw is with Officer Douche for a significant amount of time after being found in this alleyway. And I understand that she's inebriated. I don't think there's any question that she's inebriated, but certainly there's no suggestion that she's so inebriated that she doesn't have any sense of what's going on.
Well, I think you're talking about the issue of excited utterance now, not the.
No, I'm not. What I'm getting to the primary purpose, Your Honor, excuse me, I'll move a little faster. So in terms of the primary purpose, she goes into the ambulance, and the primary purpose of her going into the ambulance is to be evaluated for medical treatment. No question. Don't think anyone could argue otherwise. The primary purpose of her statement of sexual assault within the ambulance is not related at all to her medical care.
Well, so we presume that the EMT asked her what happened after the victim asked that the two male trainees leave. And the victim answers, she was forced up against a wall, she was thrown to the ground, and the male's fingers penetrated her vagina. Seems to me that each of those is a response to the EMT's inquiry about what happened that the EMT would want to know about in evaluating what the victim's injuries might be and what kind of treatment she might need. 3 different ways in which force was applied to her.
But when Ms. Shaw is making the statement, so Ms. Shaw first asks these other EMTs to leave. And then she's making a statement. That statement is an allegation of sexual assault. So when she asks what happened, she's showing all these visible injuries, like she's got the knees that are all scraped up. She has some other bumps and bruises all of her body. And when the EMT asks what happened, she's saying, what's happening with all of this going on over here? What Ms. Shaw is responding with is an allegation of sexual assault. And her intent, based on the fact that she's asked these male EMTs to leave, which indicates some level of discomfort by her, her intent is to say to the EMT, I was sexually assaulted. That's what she's saying. She's not saying I was hurt. I have I have vaginal trauma. I have the particular context of this sexual assault created these injuries for me. She's making an allegation of sexual assault. When you're making an allegation of sexual assault, the purpose of that statement is to make clear to any sort of investigating or prosecuting body that you want it to be prosecuted.
Well, the EMT says, I asked her what happened. I started my assessment. And the victim's answer is not, I was sexually assaulted. The victim says, I was forced up against a wall. I was thrown to the ground. His fingers penetrated my vagina. Those seem to me to be answers about what happened to her physically that might have led to injuries or other conditions that the EMT would want to know about from a medical standpoint. It wasn't an accusation of sexual assault, which the victim could have phrased that much more directly if that had been her purpose.
Well, again, I think when you consider the full context, I think it is an accusation of sexual assault. She had just told Officer Douge that she had not been there against her will. Nothing had been done against her will. She's got 10 minutes there to sit there and think about it, 15 minutes to sit and think about it. She goes into the ambulance. She asks the male EMTs to leave. That is a key piece of information. And then she makes that statement regarding, and again, she's bawling while this is happening.
What is the importance of asking the male EMTs to leave, other than suggesting that she's embarrassed about what's happened to her and doesn't want to talk about it in front of 2 men that she doesn't know?
I think the significance is that she's about to make a pretty significant reveal that she hasn't made yet. She has not made any sort of reveal to anybody at this point that that she was there against her will, that anything had been done against her will. And so I think the implication here is that she wants to make a reveal in a private setting, which actually Mr. Lynn implies that she wants to make this reveal in a private setting, and maybe to some extent a confidential setting. Confidential isn't really necessarily the right word. It is more private, because the expectation would of course be that some sort of allegation like that would be shared with the police.
Mr. Dressler?
Yes.
She spoke to the police officer first, right?
Sure.
So if it was her design to report something that would play in a prosecution or investigation, why would she wait to speak to a non-law enforcement person?
Took her some time to, well, I think the implication of the trial attorney would be that she concocted a story in between. I think that was the implication at trial. I think there are a lot of reasons she might wait. She might need time to process it. She might have been continuously sobering up. Her initial reaction may have been one
or
to
she
say,
wasn't,
no,
she wasn't
making,
or she wasn't making a report of anything that she believed to be used, or a reasonable person would believe be used in investigation. Instead, was making a confidential statement to an EMT.
Hey, Your Honor, I just think with the investigation still ongoing, when she sees Mr. MARRERO-MIRANDA handcuffed right in front of her, she's standing 10 feet away from them as they're separated. He's placed in the back of a police cruiser. She knows that this is a sexual assault investigation, regardless of what she said to Officer Douge. Because remember, Officer Douge testifies that she's continuing to ask her about this situation throughout that 10 or 15 minutes. So any reasonable person in that situation would understand that this is an ongoing sexual assault investigation. Just regardless of what's coming out of her mouth. She knows that they're investigating a sexual assault. She has no pants on. She's found in an alleyway with a man who is then found in handcuffs in the back of a police cruiser. Anything that comes out of her mouth is going to be used in that investigation and prosecution. I don't see any other way that she can interpret the situation.
Why would it be presumed that she would know that a statement to a medical professional would automatically be used by the police? We're not talking about lawyers or judges who are familiar with how the criminal law operates. What we have here is a woman who doesn't talk to two young male trainees and who are police officers, and she withholds information from them until such time she gets to a medical professional. Why do we assume that that means that she knows it's going back to the police?
I think, Your Honor, the reason is because she is so deep into this investigation, and she's living inside this investigation, for lack of a better term. And that's what distinguishes this from the Figueroa case, this nursing home case, where this woman with dementia makes this report to a staff member, but police aren't involved in any way. They don't know. She seems to think that this was some sort of test, even though it was an obvious sexual assault. Yeah. But I think that's the big distinction, is she's just there. She's in the entire experience. If police were there in Figueroa, standing right outside that bed, I think maybe it's a big difference.
All right. Well, your time is up, and your time is up, and you've made your point. Thank you.
Thank you.
Thank you. Mr. Lynn.
Good morning, Your Honors. Paul Lynn for the Commonwealth. In the Imbert standard, which I cite in my brief, which is, of course, based on the later Supreme Court cases, they explicitly say that the standard for testimonial statements does not depend on the subjective intent of this particular victim, but on what a reasonable person would expect in her circumstances would expect to happen. And in this case, as the Justice has been hinting throughout this argument, or saying throughout this argument, there's just no reason that she would believe that these statements are going to be part of the investigation. She is in an ambulance, she's being questioned by an EMT, and the EMT asks her, what happened? There's no way she can interpret that, the victim that is, can interpret that as anything other than a medical question. And she responds with, what caused her injuries? I was pushed against a wall, I was pushed to the ground, and fingers were inserted inside my vagina. Notably, she doesn't say anything about consent. She doesn't say anything about the defendant's identity. She is simply reporting what happened to her that caused her injuries. And in those circumstances, this statement simply is not a testimonial statement for constitutional purposes.
Do Imbert and Wordsworth supersede Gonzalez only for the purposes of statements to police, saying we no longer apply the testimonial per se test, we look instead at what the primary purpose was? Or do Imbert and Wordsworth also apply to statements that were previously considered testimonial in fact, and announce a new test for determining whether they are testimonial in fact?
I think they definitely apply to statements that are testimonial in fact, because that's the situation in which the court was looking especially at what the person would what the declarant would expect. If you're being interrogated by the police, that's almost always, the result is almost always a testimonial statement. Also, I will point out—
Can you point to anything in Wordsworth or Imbert or any other case that makes clear that the test for determining whether a statement is testimonial, whether it's to a police officer or someone else, is now the primary purpose test, and we don't look at testimonial per se versus testimonial in fact anymore?
I don't think that Imbert and Wordsworth did away with the distinction. Again, I think the point is that if you're talking to the police, if the police are asking you questions, then anybody would expect, whether you're looking at it under the per se test or the testimonial in fact test, that this is going to be used for prosecution.
Well, unless it's an ongoing emergency. So,
right, yes, of course. Okay. I can't point off the top of my head to any language in Imbert and Wordsworth that specifically say this, but that's my memory, and certainly it's my memory of the cases, and certainly it stands to reason. I'll point out also, even if this was testimonial, which we definitely don't concede, there is cross-examination here. Now, of course, the cases say the witness has to remember in order for it to be effective cross-examination. But here, the lack of memory is, in fact, used by the defense as evidence that the Commonwealth can't prove that this was non-consensual. And the victim is on the stand. She's before the jury. Her credibility is at issue in the courtroom. And she says, I don't know how I ended up in the alley. I don't remember how my pants came off. I don't remember these statements. That's under the circumstances of the case, is where the question is whether or not the defendant was sexually assaulted and was subject to sexual activity, I should say, and then whether she consented to it. This is pretty powerful cross-examination because it implies that the victim didn't know what happened. And I was just looking back over the argument. It really, although the judge mentioned intoxication, really this was argued as a consent case, or lack of consent case, I should say. Turning to the excited utterance, especially whereas here the witness is present and the statement is non-testimonial, the excited utterance standard is very broad. It's left to the judge's discretion. Here you have the traditional evidence that the defendant, excuse me, not the defendant, the victim is, she's shaking, she's sobbing. These are the traditional indicia of a statement being spontaneous. And the fact that she says to the police officer, I'm not here against my consent, again, goes to her credibility, which is actually makes the statement less. How do I phrase this? It adds to the fact that this issue was before the jury. This issue was considered in the courtroom as opposed to this being based totally on an an out-of-court statement. And unless there are any other questions, the Commonwealth would rest on its brief.
Seeing none, we thank you both, and we'll take this under advisement.
Thank you very much, Your Honors.
All right, we're live.
Welcome to the Appeals Court. I'm Justice Meade. With me today are Justices Sullivan and Sachs will be the panel for this case. Hopefully we won't have any technical snafus, but if we do, we'll reestablish contact so you each be able to provide your argument as planned. With that, we'll call our next case, which is 2019 P181 Commonwealth versus York. Mr. Rotundo. Mr. Rotundo, go ahead.
Good morning, Your Honor. May it please the court, Attorney David Rotundo for Mr. Colin York.
If you have the YouTube feed on, could you shut that off?
Yes, I'm getting a delayed reaction here. I will. Sorry. Yes.
All set?
I'm trying to get the video, Your Honor. Sorry. Having technical issues here. Can you hear me?
Yes.
Okay, I will continue. I can't see the full panel, however, I will continue. The first issue in this case is whether the motion judge erred in denying the defendant's motion to suppress evidence from 67 Pleasant Road. There was an evidentiary hearing and findings of fact by the judge. And I think this issue, to get right to the point, really is controlled by the De Benedetto case, 427 Mass 414. In that case, they found an early morning entry alone supports a reasonable belief that the defendant was present at the residence. And in that case, the entry was between 5 and 6 a.m. So it's our position that the entry in this case was 6:53 a.m. And
but they were there before that, Mr. Rotundo.
Yes.
They were there before that, right? They were there at 5:45.
Well, yeah, and I think that's the crux of my argument. They were there at 5:45. However, they did not enter until 6:53 a.m. So the sole issue in this case, and I would argue that we really don't know if they remained at that residence for that hour and 10 minutes. It seems unlikely that they would go to the residence, knock on the door, see if the defendant was at the residence, and then just wait around an hour. So it's our position.
Well, I mean, even though I don't believe there's any evidence that they left, there's several indicia that would indicate that they had a reasonable belief that Mr. York would be there. It was the house he grew up in. The police were his football coach. They knew both of his parents. They knew both of his parents had recently died. There had been an incident involving Mr. York at that residence. I mean, this is Montague. Did you ever been to Montague before? It's a small place.
Okay. Well, I would argue that, the Gentile case, 466 Mass 817, in that case, they found that the officers knew it was that defendant's residence, but there was no information to indicate he was at that residence at a particular time. I realize we have the physical surveillance factor in this case, and I think that is the most compelling factor. However, we don't have any third-party information. The defendant was present at the house, and there was no information as to his daily routine. So I would argue that this case hinges on whether the court accepts the fact that the defendant was at his residence at 5:45 a.m. If you do accept the fact that the police were maintained constant surveillance from 5:45 to 6:53 a.m., which is not in the record, I would argue that that would not be enough to justify an early morning entry based on the Benedetto case. So I would just defer to my brief for the remainder of that argument, unless there's any questions.
Did you want to discuss the second issue?
I would only to say that there were two letters, Your Honors, the February 16th and the March 2016 letters. And I would just argue that, I think the main issue in that case, the problem with my argument with this issue is that the mother and daughter lived at the same house. So I would defer to my brief on this.
I just have one question to clarify. It seems from your brief that, when we back up, Mr. York was convicted of 2 counts of violating the 209A, right? According to the indictments, there's the February incident, which is the Valentine's card, which you clearly challenged. And the second indictment related to the March 16th letter about uttering wicked things and blasphemy and utterance and getting punished. You don't seem to make an argument challenging the sufficiency of that. Is that correct?
Yes, Your Honor.
Thank you.
That's really all I have in this case, Your Honor.
Thank you.
I defer to the brief.
Ms. Von Flatten.
Good morning, Your Honor. May it please the court, Cynthia Von Flatten, Assistant District Attorney for the Northwestern District for the Commonwealth. With respect to the first issue, Your Honors, Judge Roop found that the arrival at the defendant's home, his longtime family home, was at 5:45. And then she made findings that the police proceeded to call the defendant on his cell phone. They knocked on his door. They used a bullhorn. So there's no information that would lead to an inference that they would leave the residence and go somewhere else before they finally entered the residence at 6:53 in the morning. So the logical inference is that they were there at 5:45, and under the case law, federal case law as well as state case law, it's clear that if police arrive between 5 and 6, there's an inference if there is no other information that a defendant goes to work or works overnight or leaves particularly early or something. There's an inference, strong inference, that would lead to specific articulable facts that the defendant would be in his home, probably asleep. And that was exactly the case here.
And again, for the benefit of the students, there had also originally been evidence that they had attempted to call him on his cell phone and received pings indicating that he was in the house, but that under our recent precedent involving location evidence of cell phones, that evidence was suppressed. So in real time, they had the pings, but for purposes of the legal issue before us, that is suppressed.
Correct.
And that is why one reason why we find ourselves in a somewhat unusual factual posture.
Correct, Your Honor. I think that the police originally believed they had an abundance and were very, very careful to try to make sure that the defendant was there or that his cell phone was there. And in this day and age, one would expect that one doesn't get very far from one's cell phone. So anyway, they believe that they had an abundance of information, but the ping evidence was suppressed. But nonetheless, under the case law, they still had sufficient information.
Based on your argument is that the early morning hour is enough under De Benedetto and subsequent cases.
Yes, and this wasn't just, a short-term residence. They had information that that this was the defendant's long-term family home, and that police had actually been there 11 or 12 days earlier. So that was also important information. That was, at that time his domicile. So there would be no reason to believe that he would be somewhere else, and in fact, specific articulable reasons to believe that he would in fact be there. With respect to the second argument, under the Latimer standard, the Commonwealth was required to prove that there was a restraining order, that it was in effect, and that the defendant had notice. The defendant does not disagree with that the Commonwealth met its burden on those three elements. And then the fourth element would be that the defendant contacted the victim, and this time through a third party. The Valentine's card and the letter were addressed to the victim's mother. They lived together. In fact, the victim was present when the Valentine's card was actually opened. It was in the context of the victim was already a witness with respect to earlier charges, and the card and the letter both made reference to lying and telling the truth. They had had a romantic relationship, and it could be expected that if they had that relationship, one would get a Valentine's card. The mother had never received a Valentine's card from the defendant. They didn't have that kind of relationship. They knew one another. The mother had gone over there and brought food to the defendant and his family and helped with the garden and so forth, but there was no romantic relationship, and she didn't ever expect to get a card from him. So I think that the evidence was more than sufficient for the jury to find that those cards were intended for the victim. There was also a third conviction for violation of a restraining order for a telephone call that the defendant made from the House of Correction, and that was 4 days after the Valentine's card arrived. So it was a hang-up call, but the records from the House of Correction would indicate that it came from through the defendant's PIN number. And it was, in fact, the defendant that made that call. It wasn't actually a hang-up call. I think she hung up, but it came out that the call was going to be from the defendant. They didn't speak. She hung up before then, but the records would indicate that call. So in the context of the time frame when the mother received the card and the letter was right when the victim had also received a telephone call and was a witness in an ongoing proceeding.
Can that telephone call serve as evidence of the defendant's intent with the Valentine's card and the letter in March?
Yes, I believe so. You would consider the cases were all tried together. The evidence, the testimony was with respect to what had happened in that month, and it would be reasonable to infer some intent on the basis of that phone call as well as the content of the letter and the context of the relationships between the defendant and the victim and the defendant and victim's mother.
And who do you say hung up?
I believe that the victim hung up before so that there would be no contact.
And how did she know it was him to hang up on?
Because there was a recording that said this is a call from Colin York. And then the records showed that the call was in fact placed.
And when the name was announced, it was in his voice.
Yes, so yes. If there are no further questions, the Commonwealth would rest on its brief.
Seeing none, thank you. Thank you both.
Thank you.